We're a registered business broking firm. We focus across Australia and facilitate the buying and selling of financial planning books and practices. Today we're talking to Martin Checketts from Mills Oakley Lawyers about some of the legal aspects of buying and selling a financial planning business.
As most people know, there's something of a demographic succession crisis in the financial planning industry. The baby boomers turned 65 in 2011, and the large majority of owners of financial planning practices are firmly in that baby boomer generation. The average age of a principal of a financial planning business, I believe, is somewhere around 57 or 58 years old. So certainly a number of owners of financial planning businesses are turning their mind to succession and how they might best effect that, be that through selling their business or client book to a third party, or be that through bringing about some intergenerational succession by perhaps selling down the business in chunks or in stages to their management team over time. And it's that option of selling down to the management team and bringing in a new equity partner that I'm going to talk about today. From the business owner's perspective, it's very important, I think, that there is a clear and transparent path for their senior managers to become equity owners in the business. An issue that we often see is that business owners make somewhat rubbery or translucent promises to their senior employees about equity participation, yet there's no clear rulebook or roadmap as to how that's going to occur. And the result of that is often some angst and tension and dissatisfaction with those senior people, and the risk being, of course, that they then leave the business and take clients and therefore take value with them. So the first thing that I would say to any business owner who's looking to sell down equity to their senior management team is that it's very important to have a clear and transparent process. There are a number of models under which you can sell down equity, and it's important to give some good thought, and often some thought with an independent consultant around which model works best for you. We've certainly seen a trend in recent years of sweat equity models. In other words, senior employees being allowed to essentially earn equity in the business through their executive contribution. So if they hit certain performance-based KPIs over time, then that will trigger either for them to be gifted or to be sold equity in the business. Another way to do it might be to sell down the equity up front. And certainly there are some banks out there that can offer some really good and creative funding packages to make that happen. Another way might be to sell down equity over time, either on vendor terms or perhaps through the use of some put and call options. From a legal perspective, when I'm working with a business owner who's looking to sell down equity to their senior managers, the most important document is the shareholders' agreement. This is the document that will regulate the relationship between the founder and the new equity holders going forward. And there are a number of important matters that the founder needs to take into account when drafting that document. Those factors might include control mechanisms. For example, will the founder retain control at the board or the shareholders level? Or will there be certain key decisions, such as a fundamental change to the nature of the business, selling the business, acquiring another business, changing dealer group, etc., that should properly require the unanimous approval of all shareholders, including the new incoming equity partners. Another issue would be restraint of trade, to ensure that all shareholders are bound by appropriate and robust obligations to prevent them from competing with the business or soliciting clients for a competing business, both while they're an equity holder and also for a certain number of years after they sell their shares.